Hi everyone, it's James and Cristy from Community Legal Centres Queensland. Welcome to another one of our webinars. This one looking at how lawyers talk to clients and what we can learn from a research project that Cristy undertook a while ago, and there's lots to learn from that project. So it's a really interesting and useful webinar that we're all really looking forward to. Can I begin by acknowledging the traditional custodians of the lands on which we're gathered? For people tuning in from around the country, so we all live and work on Aboriginal land, and acknowledge traditional owners, elders, and welcome any Aboriginal and Torres Strait Islander people who are with us today. And I think particularly recognise that this topic, which is about talking to clients in a way that is accessible, is something that many of us can bear in mind in the work that is happening in many community legal centres across the country, working with Aboriginal and Torres Strait Islander clients and communities. We emailed around a link to Cristy's Prezi. Cristy doesn't use PowerPoint, which is refreshing. So I'll link to that Prezi that's on our website, and we'll also just put something in the chat box now so that you can access that if the email didn't arrive at your end. We're hoping that the webinar will be recorded as long as the technology works for us, and we'll have a recording up on that same web page in the next couple of days. A couple of ways that you can ask questions as you go. You can press that button that looks like a hand on your GoToWebinar control panel. We'll see something that looks like a hand going up at our end. We'll be able to unmute your microphone and you'll be able to ask the question that way. The other way that you can ask a question, and perhaps the easier way, is to type your question into the questions box, which you should find easily enough on your control panel. And in fact, Cristy will be using that question box as part of the presentation, so stand by. There is a little bit of audience participation, which is always very well received in webinars and in other CPD forums. I think that's some of the administrative stuff out of the way for me, so I might hand straight over to Cristy. Cristy works in the policy space here at Community Legal Centres Queensland. She's been with this organisation for over 5 years in different iterations. She's worked in a number of community legal centres and also, as you'll find out, taken a particular interest in language and linguistics in the context of the work CLCs do. So can I, on behalf of people clapping and cheering and welcoming Cristy, thank you for this presentation and hand over to you.
Thanks, James. It is always good to talk about a topic that you're passionate about, especially when you have the floor and nobody can really interrupt easily. So thanks for that opportunity. I guess the first thing that I thought it would be worth talking about is thinking about why this is important. Why would we be talking about communication, particularly in a community legal centre context? We need to be good communicators, because if we're giving advice to clients, we need to make it count. Whether we're volunteering our time and spending your evening giving legal advice to people, or if you're a staff person at a CLC and using the scarce resources to give legal advice, we really need to make it count. So if that client can't understand your advice, then you've wasted your time and theirs, is the short message. So what am I hoping that you will all get out of this session? I'd like people to walk away thinking about the language that you use and the consequences of using particular language. So I'm not an expert in this field. I'm not the person who's going to tell you what is exactly right or wrong. But if we leave a session like this and lawyers and others are thinking about the way they speak to clients, then I think that's the first step. I've got an overview up there on the screen just to let you know where we're going in the presentation. So I'll give you a little bit of background about linguistics and particularly language and power, then look at some of the previous studies, then what I found in my project, and we'll finish up with just a few practical tips. I think I've already covered off why it's important. I suppose the final aspect of that I haven't mentioned in the intro is this idea of a self-reflective practice. And I think, in my experience as a community lawyer over the last 15 years, I think my communication style has changed as I've become a more competent lawyer and a more confident lawyer. So I certainly acknowledge that it's not something that we are born with, but it's something that we need to work on in our practice all the time. So if you can walk away from this presentation having some more self-reflection on the way you communicate, I think that would be a valuable thing. Okay, we might start just with a small bit of participation by you guys, just to get your head in the right space. I just want you to think, and I'll only stop the presentation for a moment or two, but if you just think about the last advice that you gave to a CLC client, and just jot down a couple of the legalistic words or some of the legalistic concepts that you needed to explain to the client, and reflect on whether or not you did use the legal jargon or if you managed to use a different word. And then if you did use the legal terminology, to jot down an alternative that you might have used. So I'll just let you reflect on that for just 30 seconds or a minute. We won't stop for long. So if you could enter your notes into the question box, and then I can read some of them out to people, that would be useful. I won't read out who you are, but I can just throw out some examples once we've stopped our own reflection, if anyone would like to do that. Got one example coming through, that is people saying, we'll discuss your matter. Matter is such a common way that lawyers refer to things, but you might be able to say something like the problem we're talking about. We also often use terms like the other party, and that makes perfect sense when you're talking to another lawyer, but you might describe that person as your ex or your ex-husband or your ex-wife. Seeing a few come up. Parental responsibility, someone's described that formal term to describe then someone who makes the big decisions for the children, such as where they live and where they go to school. Someone else has got words such as trustee, creditors, moratorium, waiver. You know, there's all these legal words that we throw around all the time. Sheriff sanctions, seeking an adjournment, the assignment of a lease. So these are all things that when you're talking to lawyers makes perfect sense, and when you're talking to a client makes no sense at all. So I'm not seeing any more pop up there now. So I might share the couple of examples, or the one example that prompted me to do this research project in the first place was that I read a little project that had happened in the Northern Territory, where a young Aboriginal man had gone to the equivalent of the magistrate's court for quite a minor matter, but he was given bail. And the next time he was supposed to turn up to court, he didn't turn up to court. So of course it became a much more serious matter because he had then failed to appear, which is of course more serious than what he was initially charged with. And when it ultimately came to talk to that young man about why he hadn't turned up, when he heard, what the magistrate had to say, it was bloody, bloody, blah, bail. And the only way he knew the word bail was, I've been bailed out of trouble. And so he just thought, well, I've been bailed out somehow, this is all sorted out and I don't need to do anything more. So he didn't even realise that he had to come back. And it was just one of those, to be honest, I'd never thought of bail as a particularly legalistic term. I thought it was something that would be in the common parlance or that people would use. But it became so obvious that that was such a huge problem for that young man, and it had really serious consequences. So that little anecdote was what kind of prompted me to look at this research project at all. So hopefully that's just given you a bit of an idea to just think about in your own practice, what are the sorts of words that we're talking about. But we'll get into it in a little bit more detail now. So linguistics is the area in which I did this research. It's the study of language. There's lots of different areas of study within linguistics, but this idea of looking at how lawyers and clients communicate falls within what's called sociolinguistics. And that area includes the study of how our society can be affected by the language that's used in it. So looking at that crossover or the information flow between society and the language that we use. Sociolinguistics is particularly interested in language and power because language is a vehicle through which power can be demonstrated, particularly in institutional settings. So we're talking about in government, in professional interactions and those sorts of things. We can see that there's power involved because different language is perceived as appropriate or not appropriate in different settings. So, you know, as I was sort of listing out those examples that people had thrown up into the comment boxes, if you're talking to another lawyer, it's in fact expected that you would use that legal shorthand, that you would talk about parental responsibility in a way that everybody knows what you're talking about. However, in a different context where you're talking to a client or where you're talking to someone at a barbecue on a Sunday afternoon, throwing around those terms isn't useful, and in fact, it's detrimental to the communication that's happening. So we can see that different language has a different value in different settings. We often see power demonstrated in legal settings. So, for example, when the police are interviewing a suspect, there's no doubt in anyone's mind where the power rests in that situation. Likewise, a judge in a courtroom. And there are good reasons for having, in a societal sense, there are good reasons for having those power differentials in some institutional settings. More surprisingly though, a power differential can also be seen in conversation between lawyers and their clients. Now, when you talk about a police officer and a suspect, or a judge and the people in the courtroom, you can understand they're not necessarily on the same side, for want of a better term. However, a lawyer and their client, most of the time at least, should be on the same side. So to me, it was a little bit surprising that this power differential would be obvious in lawyer-client communication. The final thing I wanted to say on language and power, following on from something I mentioned earlier, that the same language has different value in different settings. If you think about the difference, talking to a friend about a wild party that happened next door, no doubt for comic value or to make the story more interesting, you would use flowery and expressive language. But you compare that with if you were giving evidence in a courtroom of what you had witnessed when the party was happening, you would be expected to just give the facts and to have more formal language and not to have any of the flowery descriptors. So I just wanted to paint a bit of a picture about how there's this idea of the same words having a different value depending on the setting. I'll talk briefly about the previous studies, because that's where they really set the groundwork up for us to understand how this power can be demonstrated by lawyers when they're speaking with their clients. There haven't been many studies in this area. As you can imagine, the content of discussions between lawyers and clients is often sensitive, and of course legal professional privilege is an issue as well. So there really haven't been many studies around the world using this sort of data. The studies that have been done, the handful, have overwhelmingly shown, though, that lawyers commonly use traditional or authoritarian styles of interaction rather than a participatory style. So I'll drill down now into what I mean by that authoritarian as opposed to participatory style. So an authoritarian style of interaction has a number of linguistic indicators, and I'll go through each of those now. The first indicator is a lack of the usual conversational openings. So where most conversations start with greetings, often a legal advice session will not start with any normal greetings. People get straight down to business. The second indicator is register. So that's a formal way of saying the type of language that is used. So in a legal sense, we think about legalese or the technical jargon that, that lawyers may use, as opposed to describing something in layperson's terms. But register also covers how informally or formally a person speaks. So that's the way in which they construct their sentences and generally the type of, the level of complexity with which they speak. The third indicator of power is controlling the topic of conversation, including by asking closed questions and interrupting often. So probably most of us learned in law school about asking open-ended questions or closed questions, particularly in a courtroom context or when you're getting evidence from a witness. That asking open questions is very important, but a lot of the time when people are wanting to get information from a client to give advice, they will ask closed questions. So not really giving the client the floor, but instead asking very specific questions that often will have a yes or no answer. This controlling the topic also includes interruption. So if someone is speaking and they are carrying on a thread of discourse, as you can imagine a client might, and the lawyer all of a sudden has a thought that they need to slightly change the topic to get some different information, they might interrupt the client at that point. So there, so far we have 3 of the indicators of power. There are another couple to go. The next is that the lawyer may demonstrate a limited reaction to displays of emotion. So where the client does display emotion, it's often glossed over by a lawyer who is using an authoritarian communication style. So often not acknowledged at all, and certainly not dealt with in any way. Finally, there are forms of address. So what, if anything, do you call the client, and what do you suggest that the client calls you? So in the same way as the conversational openings, often in a legal context, the research found that lawyers who use an authoritarian style of communication will not introduce themselves necessarily, and certainly won't ask the client how they wish to be addressed. So they're the indicators that previous studies had found demonstrate that a lawyer is using authoritarian communication style. So I'll come back to those in a little while because I used some of those to investigate the communication style in my research project. But I thought it worth talking about some of the other findings from projects just to paint a bit of a picture of what these earlier studies had found. Some of the linguists had argued that lawyers and clients indeed inhabit 2 different worlds. The real world and the legal world. That this study found that there is a need for different language in each of those domains, and the lawyer's job in fact is to translate the client's real-life version into a legal framework. The clearest example of this, I know from my own experience, is thinking about when you're drafting an affidavit for a client, that you're taking their words, their story, what has happened to them, and you're putting them into a legal document, which will usually end up sounding quite different in tone and in language to the way that it was described to you. The next thing that these studies found was that lawyers will often make the distance between them and the client seem large. So this is often done by if the client tries to use legal terminology, which apparently is a reasonably common thing, the lawyer will often either dismiss the client's use of that legal terminology or will correct it in some pedantic way. So by this distancing, there's research, or there's been a fair bit of work in talking about professionals and their need for autonomy. And so that, I think, fits within this idea that a professional needs to show that they are independent and they are, I guess, of a different persuasion to a layperson. One study found that this this distance between the lawyer and the client was a reason for disappointment on both sides of the communication. The clients complained that the lawyers failed to grasp the human side of their problem and were only interested in the legal outcome. While, of course, on the other side, the lawyers complained that the clients were too emotional to get to the bottom of the legal issue. So you can see the tension or the problem when the two parties to the conversation have different expectations and different needs at the beginning and what they're expecting to get out of it. If those needs aren't met, it can lead to disappointment on both sides. And I'll just leave you with one final study. And I guess the reason I'm giving you these is just to paint this snapshot or this picture of what other studies had shown was the communication style of lawyers in general. So this other study found that the lawyer should, in fact, allow their client to tell their story in a narrative way at the beginning of their interactions if they ever want to be able to deal with the legal issue. And if they don't, this research project found that the client may well, in fact, spend the entire interview attempting to get back to their story. So while often the lawyer would be wanting to cut the client off or say that they were moving on to the legal problem solving before the client felt like they were finished telling their story. And a lot of the time the lawyer's doing that with the best intentions because they want to make the most of the time that is available to them to actually give the advice. But this project showed that it ended up not being a very good use of time because the client kept bouncing back to the facts, to the initial story, and that in fact meant that the lawyer had hardly any time to really truly give the advice during their session. Okay, so that's a little bit of background about what previous projects had found, but my study was a very small exploratory study. It was for a Masters of Applied Linguistics at the University of Melbourne, and it was really a very small project, but the results were interesting because having read all of that research that I just outlined for you, I was expecting to find that when I sat in and recorded advice interviews at a big community legal centre, I was expecting to see that the lawyers would use an authoritarian style because that's what everyone had found in their research projects before. Imagine my surprise when that was not the case, and in fact, very few of those indicators of power were used in this setting. So now I'll go through and talk to you about how the project worked so you can get a bit of a picture. So I went to a generalist community legal centre that uses volunteers in evening advice sessions. So generally the advice sessions in this centre are limited to 20 to 30 minutes of advice. This setting, so a self-help setting I'll call it, is different from any of the previous studies. So the previous studies had all involved either fee-paying clients or clients that would receive legal advice and then legal representation by the lawyer that was giving the advice. The setting we're in here for my research project, though, is where the client walks in, gets 20 to 30 minutes of advice, and then is expected to go out and self-help, so expected to go and take the next step in their legal action themselves. I approached clients who indicated that they used a language other than English at home. The reason I chose those clients is because I thought the communication difficulties would be exacerbated for clients who spoke English as a second language, when in fact I think that decision probably confounded my study. I think ultimately what happened was many of the lawyers realised quite early on in the interviews that the clients did speak English as a second language, and so I think in fact they changed their usual communication style to be more appropriate for English as second language clients. And so I think probably that's one of the reasons that my study showed quite different results to anyone else, but we'll get onto that a little bit later. So once I approached the clients to see if they would participate, and if they said yes, then I put a note on their intake sheet for the lawyer to talk to me before they gave the advice, and I then checked in with the lawyer to see if they were comfortable with the advice being recorded and analysed. So several of the clients that I asked declined to participate for various reasons, and I was actually overwhelmed that so many people said that they were happy to participate, but certainly there are a few for various reasons that said they didn't want to. It was very pleasing though that no lawyers said that they were uncomfortable participating in this study. So I think that in itself showed a willingness or an interest in this type of reflective practice. So that was really pleasing to me. So I then recorded the interviews and analysed them. A few moments ago, I talked to you about those 5 indicators of power or authority in communication. And just due to the nature of, or the small size of this project, I just chose 2 of those indicators to look at. So I looked at register. So a reminder, that's the type of language that was used. So I was looking at whether the lawyer used technical or legalistic language, but I also looked at that formal-informal dichotomy. So looking at how colloquially the lawyer spoke, or how, on the other hand, how formally they might have spoken. So again, a reminder, the use of register or the use of technical and formal register can place emphasis on the fact that the lawyer is a lawyer and the client is not. So I was particularly interested in that aspect. But the second one that I looked at was the simultaneous speech or overlaps and interruptions. So before I mentioned that topic control or the control of the conversation was often held onto by the lawyer by interrupting the client to demonstrate that they had control over the conversation. There are different types of simultaneous speech. So if you can imagine, an intrusive interruption is where a client might be mid-sentence describing something and the lawyer thinks that's not relevant anymore and they say, excuse me, I'll just stop you there. I need to ask another question or we need to move on. So that's what's known as an intrusive interruption. But of course, there are other times that speech overlaps. So you can imagine a client is in full spiel telling their story, and the lawyer may be making those noises, yes, I hear you, those sorts of noises are also overlapping speech or simultaneous speech, but they're known as cooperative. So they in fact indicate that the lawyer is using a collaborative communication style rather than authoritarian style. So I've given a little bit of a spoiler as to what the results in my project were, but as I said, I was really surprised by the results, and in fact it made writing the thesis much more difficult because I had to come up for a reason that my research was legitimate but showed completely different results from anything that has happened in the past. So like in other studies, the lawyers did use some formal language and legal register, but certainly they did not use as much legal terminology as one might expect. Unlike other studies, the lawyers also used informal style regularly. So this informal style was most commonly demonstrated by their use of words. So for example, to get it sorted out was a phrase that was used quite often. The informal style was also demonstrated by use of colloquialisms. So, the lawyers were using things like, you can't get blood from a stone. They were using, one of the most interesting exchanges for me in linguistic terms was a lawyer who was giving advice in a tenancy issue, and it seemed that the real estate agent was being a bit of a rogue and not very helpful. And the lawyer referred to the real estate agent as our friend. He said, our friend is not being very helpful and our friend is behaving in a way that's not necessarily appropriate. And then he went on to describe him as, I think he might be a bit of a cowboy because he's not following the rules. And this client, who of course spoke English as a second language, immediately interrupted and said, who's a cowboy? Where are the cows? And the lawyer, of course, immediately realised that the client hadn't understood, but in fact, he had been trying to use a participatory style of communication, and he's been trying to use colloquialisms to make the client more comfortable. It just hadn't worked particularly well because the client used English as a second language. Luckily, in that situation, the client was astute enough and assertive enough to interrupt the lawyer and say, "Excuse me, I don't know what you mean." And so ultimately, there was no miscommunication as a result. But it just goes to show that one style of communication doesn't necessarily work for all clients, and you need to tailor your language to the particular situation. When we talk about informal style, one lawyer even used some swearing in the advice that was given. So that's, of course, extremely informal language. This lawyer described cracked furniture in the way that she was talking about what someone could hold on to after a bankruptcy. And certainly that lawyer used other terms like that through the advice. And when I asked the client about it afterwards to understand whether that was decipherable or whether it made communication more difficult, the client certainly didn't have any trouble understanding those words, even though English was the second language. But it's certainly one that was highlighted to me as a distinctive way of communicating, I suppose, and one that lawyer had consciously chosen to use for reasons to try and be more colloquial and make the client relax. The other thing that the lawyers did in the analysis of the interviews was that the lawyers often confirmed the client's understanding of their legal situation when they got it right. So before I mentioned that in previous studies, it had shown that when the clients tried to describe their legal situation or use legal terminology, the lawyers would often sort of jump on them and be nitpicky and say that's not right. In this study, however, the lawyers often used the strategy of asking the client to describe back to them what their situation was. And even if they used legal terminology that wasn't exactly right, if it didn't matter, if it didn't go to the heart of the issue, then the lawyer skipped over it and indeed confirmed, yes, you understand your situation, and yes, you are able to understand and go and do what you need to do. So that was an interesting additional communication method that I think worked quite well for those lawyers. And in fact, empowered the client, because then they understood that they were really on the right track. So interestingly, the lawyers did not use intrusive interruptions, so those most authoritarian type of interruptions that I talked about a few moments ago. There was not even one example in this data. So instead, they used collaborative interruptions, which confirmed to the client that either the lawyer was listening, so those little back channeling cues, those little noises, yes, yes, I hear you, so they indicated the lawyer was listening, or they indicated that the client was on track. So the client was on track either because they were providing useful information to the lawyer, or they were in fact understanding their legal situation. So, as you can see, the first half of this talk, I was really talking about the power dynamics and the authoritarian style that had been found in other research projects around the world. And then we look at this project and we see that there's not so much emphasis on the lawyer being a lawyer. There was overlapping speech, but the lawyers were not being intrusive in the way that they were overlapping with the client. So I might go back so we don't get distracted yet with the practical tips. I just wanted to mention a couple of reasons that I thought that might have been the case. So there are two possible reasons. One of them I've already mentioned, and that is the English as second language status of these clients. So to their credit, I think the lawyers, none of them realised when they started the interview that the clients were English as second language clients. It was a tick box on the intake sheet, so they could have realised before they started, but none of them in fact did, but realised within a couple of minutes of the interview starting that the client did use English as a second language, and all of them identified that they changed their communication style as a result of that. So the obvious follow-up study for me to do in my spare time is to go back to this legal centre and do some more work on clients who use English as a first language and see how those lawyers communicate in that instance. If anybody has any ideas of how I could get that research project up and running, I'd be very interested to hear from you. The other reason that this project might have showed different results from others around the world is the context. So as I mentioned, this is a self-help legal centre, so someone comes in to get advice and they walk out having to take care of their legal issues themselves. So lawyers in that instance are really aware of the fact that the client needs to understand the advice that they're giving. They need to be able to take the next legal step by themselves without the help of the lawyer. That model or that context hadn't been in any of the previous studies, so that in itself may have been enough to give different results. So from the research that's out there and from this project itself, I've distilled just a few practical tips that people might like to think about themselves, some simple ideas. As I said at the beginning, I'm not suggesting that there's a right or wrong way to do this, but if we're aware of the consequences of the way we speak, then we can make, I guess, conscious choices when we're having these conversations with clients. So the first idea is of conversational openings. So the research shows that greetings are important in setting up a participatory communication style. So if you want your client to feel comfortable in the communication with you, then having a simple greeting at the beginning of your advice session is a simple and important way you can do that. Likewise with forms of address, so acknowledging that your client is a person with whom you're interacting, so introducing yourself and then seeing what your client wants to be called. It only takes a couple of seconds at the beginning of the interview, but it sets up this communication style that is participatory, that shows that that shows the client that you are a person who is willing to listen and willing to engage in a two-way conversation. I've also, it's not one of the dot points there, but just before we came in, I noted another one in that sort of vein, and that is giving an outline to the client of how your session will go. So if you know that you have only 20 or 30 minutes with the client, it's a good idea to be upfront with the client about that at the beginning, so that if you do need to interrupt because they've been telling their story for 7, 8, 9 minutes and you know that there's a lineup of clients outside and you're going to need to cut it short, at least the client doesn't think it's because you've become bored with their story or that you don't believe them or any of the other reasons that might pop into their head. If you've already described at the beginning that you'd like to hear as much as possible their version of events in just a few minutes so that you can spend the bulk of your time giving the advice, then the client has been given that heads up or been given that awareness that that might happen down the track. That's more or less giving an outline of how the session, of the advice session might go. The next on the list there is register. So remembering that's what technical language you use, but also how formally you speak. So I think, there's been a big push in this plain English movement, so lawyers are conscious of not using too much legal terminology, but I think there's still a lot of it that happens out there. And there's also this added element of the formality. So you can speak in a less formal way if you want your client to feel like you're having a collaborative approach to their legal problem. The next, that topic control. So this is those interruptions that I've mentioned several times. So I guess being aware of how it makes someone feel if you change the topic or move on when someone is still engaged in the last topic. So because of the time constraints, because of the way you often need to get to the bottom of things, there will be times, no doubt, where you have to interrupt a client or you have to explain to them that you need to move on. But just being aware of how that makes someone feel or explaining to them why you need to do it can really reduce the barriers between you and your client. The flip side of that, and something that I've used a lot over the years, is I mentioned those back channeling cues. So where you're talking, the client is telling a story and you're giving lots of those cues, yes, I hear you. Guaranteed, if you're giving those cues, the client is going to keep talking. So if you're thinking that this is not relevant or this is not something that we need to talk about now, or gee, I really think this client needs to wind up, a really good strategy is to just stay silent. And in my experience, more often than not, most people will peter out after 30 seconds or a minute of having absolutely no back-channeling cues back at them. It works particularly well on the telephone, and it's not being devious or underhanded. I think it's just a natural communication style, and one that if you don't want to be as confrontational with your client, you don't want to interrupt them or tell them that you need to move on, but it's just a way that often, if you just stop giving those cues, then the client will eventually stop talking. Finally, there's the reaction to emotion. An acknowledgement of emotion, I guess, is what I think is important. So we're not expecting lawyers to be social workers or psychologists or people who can deal with those emotional issues necessarily, but pretending that the person in front of you is not bawling their eyes out is not necessarily going to help your communication with that client. If possible, giving people time to pull themselves together is probably a good use of time, because you'll probably be able to get to the legal issues in a better and more succinct way if someone's had time to calm down. The final couple of tips are really about letter writing, so it's slightly different. So far we've just really been talking about the language we use when we talk to our clients, and certainly linguistic studies are always interested in that verbal language rather than written language. But I thought it worthwhile to mention a couple of things, just tips that I've seen over the years, some of the things that I think make it difficult for clients to understand some of the advice that goes out in letters through the community legal sector. The most important thing, I think, is getting that important information up front. So, I can think of a great example of this really long-running, it was a debt issue, and we were trying to have a debt waived, and I had a junior lawyer who'd written and had got a $10,000 debt waived for a client. It was really a great outcome, and she wrote a 2.5-page letter to the client that outlined everything that they'd done, all the legal processes and all the things that had been tried and all the comings and goings, and then in the last paragraph she said, and we've had the $10,000 debt waived. And I thought there's no way the client was going to read those 2.5 pages to get to that information. And so just having that important information up front was a much more, a simpler and plainer way to write that. And if for some reason you needed to have all that information, that's fine. But it actually goes on to the second point that I'll make about writing letters, and that is often, as lawyers, we want to make sure that we've covered all the bases. But in fact, a lot of the time, the thought process or the way that you have come to a particular piece of advice for a client, they don't need to know a lot of the ins and outs. They need to know what the advice is. And in a separate file note for the file, you can write your legal reasoning and why you came up with a certain issue. So some clients, of course, will want more information, and it will be entirely appropriate to give it to them. But if you have a client who struggles with literacy and has got lots of other things going on in their life, then perhaps you might think about just making that letter as simple as possible with your advice outlined and keeping the file note as a file note. My spiel always has to involve talking about getting rid of extra words, because I think lawyers are excellent at using 10 words when we could just use 2. Those are the practical tips. As I said, I'm not pretending that I know everything about simple communication with clients, but these are things that I learned through this research project and through my experience as a TLC lawyer for some time. I thought we would finish off just with a short TED talk from a fellow in the States. It's a few years ago now, but it just gives some food for thought about how simply we can communicate things in the legal world if we want to. After the TED talk's finished, I'm happy to take questions if people either type them or put your hand up, as James mentioned. So let's see how we go with the video.
basically, we have public leaders, public officials who are out of control. They're writing bills that are unintelligible, and out of these bills are going to come maybe 40,000 pages of regulations, total complexity, which has a dramatically negative impact on our lives. If you're a veteran coming back from Iraq or Vietnam, you face a blizzard of paperwork to get your benefits. If you're trying to get a small business loan, you face a blizzard of paperwork. What are we going to do about it? I define simplicity as a means to achieving clarity, transparency, and empathy, building humanity into communications. I've been simplifying things for 30 years. I come out of the advertising and design business. My focus is understanding you people and how you interact with the government to get your benefits, how you interact with corporations, decide who you're going to do business with, and how you view brands. So very quickly, when President Obama said, I don't see why we can't have a one-page, plain English consumer credit agreement. So I locked myself in a room, figured out the content, organized the document, and wrote it in plain English. I've had this checked by the 2 top consumer credit lawyers in the country. This is a real thing. Now, I went one step further and said, why do we have to stick with the stodgy lawyers and just have a paper document? Let's go online. So many people might need help in computation. Working with the Harvard Business School, you'll see this example when you talk about minimum payments. If you spend $62 for a meal, the longer you take to pay out that loan, you see over a period of time using the minimum payment, it's $99.17. How about that? You think your bank's going to show that to people? But it's going to work. It's more effective than just computational aid. And what about terms like over the limit, perhaps a stealth thing? Define it in context. Tell people what it means. When you put it in plain English, you almost force the institution to give the people a way that default out of that and not put themselves at risk. Plain English is about changing the content. And one of the things I'm most proud of is this agreement for IBM. It's a grid, it's a calendar. It's such and such a date. IBM has responsibilities, you have responsibilities. Received very favorably by business. And there's some good news to report today. Each year, 1 in 10 taxpayers receive a notice from the IRS. There are 200 million letters that go out. Running through this typical letter that they had, I ran it through my Simplicity Lab. It's pretty unintelligible. All the parts of the document in red are not intelligible. We looked at doing over 1,000 letters that cover 70% of their transactions. They're in plain English. They've been tested in the laboratory. When I run it through my lab, this heat mapping shows everything is intelligible, and the IRS has introduced the program. Looking at, there are a couple of things going on right now that I want to bring to your attention. There's a lot of discussion now about Consumer Financial Protection Agency, how to mandate simplicity. We see all this complexity. It's incumbent upon us, and this organization, I believe, to make clarity, transparency, and empathy a national priority. There's no way that we should allow government to communicate the way they communicate. There's no way we should do business with companies that have agreements with self-provisions that are unintelligible. So how are we going to change the world? Make clarity, transparency, and simplicity a national priority.
So a reminder, folks, there are a couple of ways that you can ask questions of Cristy. One is to type a question into the questions box on your GoToWebinar control panel, and the other is to press that button that looks like a hand. We'll unmute your microphone and you'll be able to ask your question that way. A few questions coming in. Cristy, can you explain what you mean by separating the file note from the advice?
And the next question is a follow-up to that. Don't we need detailed correspondence to cover off on risk management? So I think it is important to make sure that on your file somewhere you have an outline of all the things you considered, the reasons that you thought things were appropriate or not appropriate. I just don't think that the client needs to know all of that. If in some instances, certainly with a sophisticated client where you're asking them to make decisions based on a whole variety of information that you're giving them, you will need to give them information. So of course it needs to be in the letter. But if you're giving advice to someone, for example, in that debt matter that I said before, if we've looked at all the options and we think that asking for a waiver of this debt is the best thing to pursue, then that's the advice you should be giving the client. And then in your file note, you might put that we've thought about asking for hardship provisions, we've thought about these other aspects, we've thought about just not paying, we've thought about what the options are, and really the best one is to request a waiver. So that information doesn't necessarily need to be in the letter to the client because it's not important to the client. But yes, from a risk management point of view, if someone down the track wanted to know why you gave certain legal advice, then I think it is important to have it in a file note on the file. So hopefully, Katrina, that covers off your question.
Cristy, can I ask a question? Was your sample size too small to come to a conclusion about whether swearing is a useful or that level of informal colloquial thing as someone who does swear a lot conversationally?
Yeah, it was definitely too small to make any call on that. So it was really just an exploratory study. I recorded 10 interviews and ultimately I only analysed 3 of them because that gave enough data to write my thesis. So there's still data that is sitting at home that I could use under the ethics clearance, but it's a lot of work to analyse it, and so that's why it didn't end up happening. There's been a lot of work in the linguistics field more generally about swearing and whether it's an appropriate and effective way of communicating, and I just haven't read that research, but there is research out there that talks about it. When I was talking to various lawyers as I was doing this research project, there was really quite a varied opinion from lawyers about whether it was appropriate ever to use that sort of informal language with the client. Some who said absolutely not, and others who said absolutely, of course, why wouldn't you do it when you're speaking colloquially? So it's one that has certainly differences of opinion.
Reminder folks, there are a couple of ways you can ask questions. You can type something into the questions box, or you can press that button that looks like a hand on your GoToWebinar control panel. I don't think we've got a huge amount of questions coming through at the moment, Cristy. I wonder if when you were looking at the power imbalance or power dynamics in the space, and you identified English second language clients, how did gender feed into the discussions that you had and the literature that you looked at?
Yeah. When
you look at some of that power imbalance sometimes? And I ask that because over 80% of paid workers in community legal centres are women, and there are a number of services that take an overtly gendered approach to service delivery. I'm interested in if you looked into how gender plays into the linguistic analysis of the...
Certainly, when you look at language and power, there is a whole section of research that talks about gender. I didn't specifically choose men or women for either my clients or my lawyers, and didn't ask any gendered questions in terms of communication style or how they felt in their communication. So certainly from my research, there wasn't anything obvious or anything that I said in the thesis, but there's a whole bunch of work that's been done looking at language and gender and the power imbalances that come with that. So I think, there's just 1,000 research projects that you could do with lawyers and clients and looking at various aspects of it, because you really need to tailor the project to look at each of those issues, because the data analysis is so onerous. You need to be careful about how many different things you want to look at in one project. And yeah, it was really tempting. That's why I did 10 interviews at the beginning, because I thought I'd be able to do all this analysis, but in fact it was much more onerous than I thought it was going to be.
Cristy, there's no more questions coming through, and we are at 2:55, so we might draw a line under it there. Can I, on behalf of everyone who participated, thank Cristy for a thoughtful and insightful presentation. Cristy, can I, on behalf of people clapping and cheering wildly at computers across the country, thank you for sharing that with us. Can I thank everyone who participated? We'll, as I said, hope to have a recording of the webinar up on our website in the next few days. And otherwise, look forward to speaking to you soon. Thanks, everyone.
Thank you.